Coffee with Coker is a healthcare business podcast from the Coker Group that focuses on solutions to help healthcare organizations effectively navigate the changing healthcare industry landscape. Welcome back to another episode of Coffee with Coker. We appreciate everybody listening and subscribing. And today we have another veteran Coker team member joining us. He's been on the podcast a number of times before, but Richard Romero is joining us today. And as the title indicates, we are talking about non-competes. And we were actually talking before we went live with Richard about the fact that we talk a lot in our expertise and our content that Coker pushes out. We talk and allude to non-competes a good bit, but I don't know that we've ever actually had a very specific discussion about non-competes and some of the kind of similar type structures, and specifically related to physician contracts. But this is something that we do a lot of work on for clients. Richard does a lot of work as it relates to the fair market value analysis and the kind of expertise around a number of things related to physician contracts, but particularly when things go into different types of litigation. It's something that I think comes up a good bit. And so Richard is definitely one of our resident experts that has a lot of experience on this particular subject of non-competes. And part of this too was spurred by a conference that Richard had attended. And so it just made a lot of sense, we thought, for us to take a few minutes and talk about some of the key takeaways, as well as some of the things that have developed even fairly recently. And Richard, we'll talk about that here in a second. But let's just dive right in, Richard, and maybe just kick us off, and maybe with some of the recent developments or some of the develops over the last year as it relates to non-competes, specifically related to physician contracts and those types of arrangements.
Well, thanks, Mark, and I always appreciate the opportunity to be here. I think when President Biden took office, and this was not necessarily unique to him, but he enlivened the discussion once again with regard to non-competes in a presidential order last July, and indicated that one way companies stifle competition is with non-compete clauses, and he wanted to make it easier to change jobs and help raise wages by banning or limiting non-compete agreements that impede economic mobility. And so on one side, there is this desire to do those things. And I think on the other side, there are legitimate business interests that entities have that they've invested, and they want to maintain those. And we'll talk a little bit more about that. But especially in President Biden went on, especially as we looked at physicians, and as we know, there's generally a shortage of providers that are there, and healthcare, as we know, is a unique market. And so when we think about some of those things that are commonly expected, for example, when a sale of a business occurs, we kind of expect a non-compete to be there. And so what are some of the dynamics that play into both the need for physicians to provide services across the board, as well as the business interests in protecting what we'll say is legitimate business interests, which we'll talk a little bit more about here later.
Yeah, so I think that tees it up well. And I think non-competes in my mind are just one of the different types, and I guess you could say many different types of restrictive covenants that you'll see in many different types of contracts. But specifically here, I think obviously we do a lot of work for hospitals and health systems when they are looking at different arrangements with physicians and practices. And you always have restrictive covenants because of the things that you just said, as far as protecting business interests and their investment in those services and those service providers. So maybe walk through some of the different restrictive covenants to give a little bit more context specifically to non-competes.
Yeah, and Mark, I'll start out by saying, and those non-compete agreements can also be where an employee physician practice has employed just another physician. And
yeah.
So they may not occur. And quite frankly, that's one of the areas where we see a lot of litigation in those types of arrangements as well. But if we think about, and we want to spend more of our time today on non-compete, but kind of think about this in three big buckets, just generally. Of course, there's nuances to all of these, but one of those is what we could call maybe the traditional non-compete. And that's, thou shalt not compete with me within given area for a given period of time, or you may not provide these types of services within a given area within a specific point of time. And so sometimes we'll say, hey, a hospital will enter into an agreement with a physician and said, okay, if you leave, you can't compete with us, but you could go teach, or you could go open up a practice, but you just can't be employed by another hospital system in our service area. So there's different ways of looking at that. So all of these are always facts and circumstance specific. So we've got non-compete agreements. Another common form of this is a non-solicitation agreement. These tend over the years have become more prevalent because they tend to be more enforceable, which basically says, thou shalt not solicit my customers and patients or other employees along those lines. And then we've got just kind of your non-disclosure agreements, which you won't use confidential information or trade secrets, and defining what those are can sometimes be difficult. So those are kind of the three big buckets if we want to think about restrictive covenants. But I think for the most part, we're going to spend most of our time today talking about non-competes.
Yeah, and you alluded to a couple things there that I want to unpack a little bit. One of which is enforceability, and I've heard kind of everything across the board as far as on one end, attorneys I've heard say essentially non-competes are not enforceable at all the way to many scenarios where they are an organization is absolutely pursuing litigation as a result of a breach of a non-compete, and then kind of everything in between. And so maybe talk a little bit about that. And then also again, you alluded to this a little bit, but the nuances, not all non-competes are the same. And there can be many different nuances to them and different flavors that come. And sometimes those are they're negotiated in great detail. And so maybe talk about some of the common characteristics that we see, whether it's you alluded to geographic location or service areas or time periods, those types of things.
Right. And so what I would say is a great point before we kind of start to go down the path on this conversation, these points of conversation, is one thing is to make sure that non-competes are fundamentally governed by state law. And so there are some key things that we need to mention with regard to state law. One of the most common is whether blue lining is allowed. And that is basically where a trier of fact will go in and decide, okay, we're going to strike these provisions or change these provisions, whatever the case may be to meet state requirements. But the rest of the document is generally held to be enforceable. Other states, it is an all or nothing kind of scenario. If any point is considered unenforceable, the whole document is essentially thrown out. Mm-hmm. So that's deferring, and we're not counsel, so I'm going to defer to counsel on those. However, when we think about those pieces, if we think about just that dynamic where the entire thing is thrown out, the requirements or the limitations included in those agreements, all else being equal, are going to generally be less restrictive than the same type of situation in another state. Because if I've got a risk of everything being thrown out, I don't want to go too far or too much. So there's got to be first of all, it's got to be a legitimate business interest, reasonable time frame, and different states have different limitations on those, right? A reasonable geographic area that we have. And I think foundationally and fundamentally, when we're talking about healthcare, especially as it relates to physician contracts, there is always a balance between a physician being available in a given service market to provide needed medical services versus the interests of an organization, right? So that's probably, that dynamic and that conflict is probably exacerbated in a rural market where that physician may be the only physician within 30, 35 miles, sometimes even greater, to provide that. And they get into a contractual dispute with the local hospital. Local hospital tries to enforce the non-compete. Local judges, more often than not, in my experience at least, going to say, no, we need to allow this physician. We'll deal with the financial issues, but we need to allow this physician to provide services. So I think there's a couple of things that we need to just make sure that we think about going there. Is state law specific, state in terms of blue lining or not, and then the requirements, and then just foundationally thinking about the fact that this is healthcare and physicians need to be available to provide services to patients that need them. Mm-hmm. And, depending upon the market situation, that's going to weigh into the public good versus the contractual requirement.
Yeah, that's an interesting point, because I guess in some ways you could argue that a non-compete for a physician is a little counterintuitive in terms of what you just said, being able to deliver certain services that a very, relatively speaking, limited group can, and particularly in certain areas, or maybe in a rural area or whatever it may be.
Yeah, Mark, and I think it might be helpful just to go down a quick path here of saying, what's really the purpose of a non-compete? And I think if we looked at that, first I think we'd say is, depends on who you ask, because mm-hmm. there's strong views depending upon which side of where you sign that document, your viewpoint on that. But if we think about kind of the general purpose of a non-compete, it's terms that essentially contractually prohibit a party from engaging in competitive business activity once that contracted party leaves an employer. Essentially is what we're looking at.
Right.
And so you've got those key components that we talked about is the duration, the geographic limitations, scopes of services. Those are kind of typical. But if we look at that from the perspective of the parties that are involved in that agreement, right? You've got an employer, that's a business entity that's trying to protect a financial investment that was made, perhaps to acquire a practice, capital expenditures, specialized training, which is one of typically in a number of states that are a legitimate business interest that can be protected by a non-compete. Use of confidential or proprietary information, protect access to patients, especially if that was an existing practice and they brought in a new physician. And there's, again, fundamentally, that has the effect of helping to reduce turnover costs. And I'll just make a quick plug here. There was an interesting article that came out and drew some correlations between use of non-competes and some practice characteristics, including turnover and productivity. If anybody's interested, they could reach out and I'll get them a copy on that. So that's the employer portion. Let's take a look at how the physician's going to look at this. Well, it's going to limit the physician's ability to choose an employer, potentially reduce competition, may impede access to physicians. And one of the things that we saw very, very recently as a result of the pandemic is it may deter advocacy on the part of physicians for certain types of treatments, i.e. COVID. My understanding is California right now is taking that to another level. And so there may be restrictions on what a physician truly feels about a particular therapy or procedure, and that may be curtailed. So those are some of the things that that you see the contrasting points with regard to the purpose of a non-compete.
Yeah, you mentioned earlier, and I guess we can reiterate, we are not legal counsel, and so we don't provide that. We always or typically work very closely with legal counsel, particularly on things related to contracts. But where we really play a role and where our expertise, specifically your expertise, as well as others on the team here, come in from a valuation perspective. So talk a little bit about, I guess, I want to know when a non-compete or restrictive covenants need to be valued, but maybe even start a step earlier with why.
Well, typically where we're going to see those, where we need to get involved at that level of detail, one of those is some agreements may have requirements for buyout provisions at fair market value. So when they enter into the agreement, they may not know what that's going to be at the time that a party is going to leave. So we would need to assess that at fair market value. Another period of time is when entering into an agreement, what is a negotiation of value? Or you've got a transaction to say, hey, what is this actually worth as part of an acquisition along those lines? And then the other one, which we see a lot of work in, is with regard to enforcement or litigation of a non-compete agreement. And sometimes those, when you have disputes, especially between hospitals and physicians about fair market value issues in terms of how much we're paying for compensation, for example, is what the hospital's saying, or I bought your practice for X amount. They come to find out that, hey, maybe I should have gotten that external valuation. Now I have a concern that I overpaid too much, and so I can't pay you as much as I wanted to. Well, physician gets upset. Physician wants to go practice in the local market. Hospital comes back and says, no, we're going to enforce the non-compete, end up in litigation. And we go down those paths. So those are some of the common areas where we see those types of need for our services specifically related to non-competes.
Yeah. And, I think that's interesting that there are a number of situations, I guess, where in a case involving litigation around restricted covenants, that we've seen a lot out there, and these aren't always as clear as the black and white ink tries to make it out to be in the contract itself. Meaning there's, and correct me if I'm wrong here, maybe I'm making a incorrect statement here, but there can be nuance to not just the terms of the restricted covenants, but ultimately how that litigation is pursued. Meaning, is it always just kind of like a definitive amount, or is it, hey, take it or leave it? You mentioned earlier some of the I think you called it the blue lining. Can we come to some sort of agreement on modified terms, a compromise or whatever? Or is it pretty much kind of like, nope, this is what it says. It's 2 years, 10 miles, do not pass go, collect $200 type thing.
Yeah, Mark. So kind of summarizing kind of your questions, because I think there's a lot of different directions, and just talking about some of the experience that I have been involved with, where there was a physician practice that had bought another practice, for example, and they had a non-compete that they put on their books. That practice was being acquired by another entity. I was doing evaluation of the practice, looked at the terms of that first non-compete, and the value that was accredited to that by that local accounting firm was vastly overstated, because it was essentially very easy for that underlying physician of that first transaction to go and compete. And so I brought that up, and quite frankly, that was a problem for that local accountant. They ended up having to refile some tax statements, so forth and so on. So something as simple as a transaction where you're just validating some information can come up with those kind of differences. But more foundationally, all valuation is going to be, and valuation, and I'll throw in litigation along those lines. It's always going to be, and you've heard us say it 1,000 times, it's always facts and circumstance specific.
Yeah.
Right. And that's especially true with an intangible asset. And that is what a non-compete is. And what you're basically saying is what is the economic impact of this individual who has signed this agreement on the operations of my entity? And going through and assessing that means you have to assess the business overall, their role in performing those duties, or what they do for that entity, and what is appropriate as a part of that non-compete to credit them for. So there's some other more complicated factors, and I think we're going to get into some of the approaches there. But I think it's absolutely essential, because I've been involved in litigation where one side is saying the value of this is $4 million and it's pie in the sky and everything's great, and it's devoid of economic reality. And so the difference in the opinions can be millions of dollars versus maybe a few thousand. So I think it's important to dig in, understand both the operations of the entity and the role of the individual, and then assessing the likelihood of competition to be able to do a proper analysis.
Yeah, that's a pretty wide variation there. So again, it goes back to the nuance and the circumstances of each case. And I think it's a good segue talking about approaches. And I don't necessarily want to get in right now to a great deal of technical weeds here, but I think it is relevant because while, our clients and our listeners may not be valuation experts, I think there are definitely some key things to know and be aware of beyond just the basics of a non-compete. But, you talked about why and when the valuation or valuing a non-compete comes into play, but the how piece, I think, is again, there's a lot of technical detail there. So maybe just talk a little bit about the approaches that you're typically going to take.
We'll keep it at a 50,000 foot view level. So, anytime you're valuing anything, there's, the three approaches to value. And in this case, it's, market, cost, and income. Market really is not applicable, because market is going as what have other people paid for similar types of assets or investments.
Right.
Well, as I just mentioned, we're talking about the economic value of a particular individual to a particular entity. That's not going to be represented by other transactions with non-competes from that perspective. The cost approach is, what is the alternative cost to recreate, right, the economic utility of this, the effects of this individual that's under this non-compete, right? You've got, for physicians, you've got recruitment costs, ramp-up costs, interviewing costs, HR costs, all of those types of things that could be considered as part of that analysis. And then the income-based approach, which you have to be careful about, and that's a whole other detailed conversation about when is it appropriate to use an income approach, because we want to be careful about all of the Stark and AKS rules, so forth and so on. But when that is appropriate, what we're essentially doing is we're doing two scenarios. We call it with and without. One with the individual working at the entity and one without. And so, for example, if that individual is responsible for significant revenue and it goes away, well, I may not have as many people. I may not have all the same locations. So you take the net effect of revenue and expense, take the difference between those two numbers, right? Those cash flows that you would have. And then you have to have a likelihood of competition. Right? Because so you weight that that mathematical calculation, those analysis, that detailed analysis, and you want to assess the willingness to compete, the ability to compete, and the capacity to compete for the individual under the non-compete. So you're going to assess a likelihood, which is usually expressed as a percentage of that difference. So big picture, high level, what we do on all of those. So whichever one we're looking at, it's a detailed analysis of what the business does and what the individual does.
How much subjectivity comes into play when you're doing those analysis? I mean, because I have to think you can quantify a lot, but you typically can't quantify everything or incorporate 100% quantifiable analysis. So, or is it? Is there subjectivity to it?
Well, there's, and I'm going to go back and I'm going to do an evaluator speak, right? We have our guiding document for evaluation, which is Revenue Ruling 5960, which says reasonable people may disagree. And so there are going to be ranges with everything we do, but they should be within the range of reasonableness. And so we often see, just as we would see with litigation, we would see some unreasonable expectations. Again, what I would like to say is things are devoid of economic reality. that a practice that was doing X is not going to do 3 times X next year just because of this. You're in litigation. So there's reasonable, but it requires to do an appropriate analysis. It requires an understanding of the underlying business and the services that were being provided by that individual under that non-compete.
Interesting. So if we are going to bring it full circle, and by the way, I should just remind everybody listening that there is a lot to get into that we could get into, that we could be here probably all day when you think about getting into the weeds and the nuance of this type of topic. So we certainly would encourage people to reach out to us, reach out to Richard, and we can obviously answer any either more detailed questions or provide more detailed information or anything specific to their circumstances. Obviously, we're happy to do that, but I want to preface this with saying that we're literally, like you said, covering it from the 50,000 foot perspective, and there is a lot of detail that could take it different ways. But if we're going to kind of summarize, here are the key things that you need to be aware of, whether you are the employer holding the contract, or you are let's just say the physician or the clinical role employed under a specific contract with restrictive covenants. What are some of those key things to be aware of and to think about as maybe if you're going down this road?
Yeah, so I think 3 biggest things that I will say as part of this is for a non-compete to be enforceable, it has to be related to a legitimate business purpose. And that is, again, based on state law. And so that's another component, is make sure you understand state law. Get good counsel that understands the requirements within your state. But some of those kind of typical legitimate business interests would include like trade secrets, confidential information, customer, patient, vendor relationships, specialized or unique training, those types of things. So again, it's got to be enforce and protect a legitimate business interest. General competition is not considered a legitimate business interest that can be restricted by a non-compete. It's generally what happens. So just because, which is another golden rule, is that just because it's in the agreement does not mean that it's enforceable. So again, great legal counsel that understands non-competes in your state is absolutely essential. And then finally is, if you get to the point where you need to put a number on it, whether that be for negotiation, fair market value determination per the agreement, or if you are in a litigation scenario, an appropriate analysis requires an understanding of the details. You've got to understand the business and the services that are provided.
Which I have to think that's probably where the process starts for you when you or any of our team members go in to work with the client on something like this. It's get a good understanding of the landscape, the organization, obviously the nuanced details of the contract itself, but probably other contracts as well, those types of things.
Absolutely. I think my first question is, ensure that we have counsel that is familiar with state law regarding to non-competes. And then the second question is, tell me what the business does. Third question is, tell me what this individual did for that business.
Yeah, that makes sense. And again, I would really encourage people, if you're listening to this and it sparks more questions, or you need to get into some specific details related to a restrictive covenant, there's, like I said, there's a lot we could go down the road of going into more detail. But obviously we can answer specific questions. I would encourage people again to reach out directly to Richard. But Richard, this has been extremely helpful. I know we have some other information and supporting documentation. We'll make sure that's available for listeners. Again, they can reach out to us and we'll be happy to share that and answer any questions. But I think this is definitely one of those things that we get a lot of questions about, and it's becoming more and more of a thing, I guess, for our clients as we're seeing the nature of a lot of these contracts evolve. So I appreciate you giving us the quick rundown on it, and we'll look forward to maybe covering some of the other details and other structures that we see in some of these contracts in a future episode.
Thanks, Mark.
Thank you.
We hope you enjoyed that episode of Coffee with Coker, and we thank you for listening. We want to encourage all of our listeners to participate and contribute in the podcast. So if you have any questions on any of the things we discussed in this episode, any of the topics that were presented, please feel free to ask us. Also, we welcome your feedback and suggestions. If you have any ideas related to the material we discussed in this episode, or in any episode, please let us know and we'll make sure to incorporate it. And if you have ideas for topics you'd like to hear more information about in future episodes, please send those suggestions to us. We would love to hear them, and we'd love to incorporate them into our future episodes. You can find us online and on social media. Start with our website, and specifically the podcast is coffeewithcoker.com. You can also find that through the main Coker website at cokergroup.com. You can also find us on social media, Twitter at Coker Group, and then on LinkedIn, you can search for Coker Group and find our page and the page for some of our team members as well there. So you can find us and reach out to us a number of places. And then if you want to contact us directly, one of the best ways to do that, email feedback@cokergroup.com. That's feedback@cokergroup.com. And again, we'd love to get your feedback. And we'd love to encourage everyone to subscribe to the podcast so that you can be notified when future episodes are released. We look forward to the next episode, and we look forward to getting your suggestions and feedback on this episode. Thanks for listening, and we look forward to speaking with you again on future episodes.